For the reasons recorded here in our, we find no infirmity in the judgment and order dated 18/11/2025 passed by the learned single judge in WPC 3504/2025. We find no reason warranting our interference in exercise of an appellate jurisdiction. The writ appeal accordingly stands dismissed, interim order if any stands vacated. However, the appellants are given a liberty to vacate the premises on their own within a period of 90 days from today, and if not vacated within the period stipulated, the learned tribunal shall proceed in accordance with. I agree. Give the just. Yes.
Adjournment request, if any, from item number 2 to 16.
May I please, your lordship. Lordship, regard to item number 14, your lordship. I have received the instruction, your lordship. Lordship, you have circulated this. I have circulated, lordship. 1 week, 2 weeks time, any 1 week, 2 weeks time, lordship, to file my rejoinder.
As a journal slip has been circulated. Yes.
Much obliged.
12-6.
Much obliged.
Yes.
New one for item 16. Item number 17 to 25, adjournment request.
May I please, your lordship. That's why I beg to mention item number 23, your lordship.
All right.
I don't know.
Lordship, I beg to
22nd
mention
June.
item number 18.
You also circulated. All right.
Item number 28.
28, what has happened?
On the day only, not prepared. This hearing matter,
You want time?
1 day, tomorrow.
You could not prepare. Acha, this is with respect to disengaged workers of IOC. All right.
Tomorrow, Miller.
Tomorrow will not be possible now. Tomorrow we have to take a decision whether to go online and all that. We'll be issuing certain instructions. Not tomorrow, next week. As put it on behalf of the appellant. As prayed for on behalf of the appellants, let both the appeals be listed on Thursday or Friday, whichever. Friday.
In item 49, Mr. Mahmood is there.
Have you taken his consent?
No, Lord.
Please inform. Please inform.
4-6. 4th of June. Any other request?
May I please, your lordship?
Yeah.
My lord, we have filed a writ appeal on 4/5/26. Not yet listed. It may kindly be listed day after tomorrow. All right.
All.
May I please, your lordship, pair for listening for Urdu, lordship. On GTP, lordship. For Urdu, lordship.
You want it to be listed for withdrawal?
Yes, lordship. Tomorrow, lordship.
Tomorrow.
For admission, item 2.
Ring Road matter, madam. Last occasion, that Gauhati Ring Road matter. Madam.
Yes.
Last occasion, my lord, the issue was that whether we have done that comprehensive study or not. But I have specific instruction, it is going on. It will take another 90 days. Madam.
Lordship, otherwise, Lordship.
Put it on record.
Put it on record.
Put it on record
File.
tomorrow. File an affidavit. Across the board, we'll accept it.
Mile,
Need not file in the registry.
mile.
File it across the board, but put it on record, give a copy to him.
Lordship, otherwise, respondent number 8 and respondent 2 and 3 are also required to file their affidavit, Lordship. The last occasion, that was the
Where
order.
is Mr. Kakati?
Lordship, Lordship, but I think Lordship, for the answer part, it's already on the last.
No, we had asked you a simple question. Whether you have gone for that research study and whether it has been incorporated before asking the contractor to fell the trees. That was the only question before us. Nobody questions your wisdom of making the ring road. That is not under question. Even if it is under question, we will not accept it.
For the other person, Lordship, our project was already clarified on.
Mr. Borkatki, why are you talking about underpasses? We are on a different issue altogether. You are only an agency. Correct. So therefore, this you may not answer, but Mr. Goswami will. be
My
required.
affidavit will answer everything. It will answer everything.
All right, put it on record. We'll keep it next week.
Next week.
So because there is a stay,
Mile.
yes, there is no stay. There is an assurance
Undertaking.
of Mr. Goswami
Mine.
that no trees shall be
That will
felled.
continue, madam. That will continue.
Therefore, if you want to speed it up, you can do it next week.
Well, just for a moment, my instruction is that, madam, we have written to the Wildlife Institute for that comprehensive study. And they have taken 10 days to prepare a proposal, including the financial plan. NHCI has given us an undertaking that they will pay the amount to be.
They have to, otherwise. Also.
Yes. So then they have responded to us that they will take another 90 days to complete the entire study. So the question of my lord.
And you will do it only thereafter.
Exactly. Telling you.
On your, put it on record, the entire sequence, whatever you are going to do in future.
Right.
You just let us know and then we might even conclude it, not even wait for it.
Yes.
Lordship, in that case, where file it?
I think not
You
required.
file an affidavit
No.
on the, responding to Mr. Goswami's affidavit that you shall undertake all expenses.
Yes. That undertaking they have already given,
We
madam.
have already.
You have given it, inform us also.
I'll put it on affidavit.
Lordship, additional also respondent number 2 and 3 also, Lordship.
You don't worry about that.
Lordship.
You have flagged it, we have taken it into account.
Lord.
We are good for your showing concern, but then it's not an adversary litigation. We'll see and we'll do it. Take on. As grateful on behalf of the state and other respondents, let this matter come up for consideration on next Monday,
Well, can it be on next Tuesday or what?
Tuesday, next Tuesday.
Deeply.
6.
Item 3 to 13.
I think let this go before another bench. Though issues are different, but then the core issue would remain the same.
Yes, yes.
Where my brother has delivered a judgment. So
Second,
let it.
please.
He cannot be a judge. Well, let all these cases go before, let all these cases be listed before an appropriate bench, of which one of us, bracket Justice Arundev Chaudhary Che, is not a part. Place all these matters before the Chief Justice in the administrative side for allocating an appropriate bench.
Item 15.
Mr. Baisha,
My lord,
what information do you have?
my lord, I have received the instruction, my lord.
What instruction?
My lord,
If you can give it to divorced daughters, why not widowed daughters?
yes, my lord, why not?
Why not?
But we do not have any precedent on that.
No. Widowed daughters, you have included it by way of further amendment. So why not divorced daughters? Take instructions and get back to us.
My lord,
Put it on record.
my lord,
Either you say that you will not, then we'll pass an order.
my lord, yes, my lord.
You are the standing counsel for the High Court.
Yes, my lord,
And the High Court has made a request to the government.
yes.
Who appears for the government?
I think.
Ms. Sharma, you will not be able to commit. This has to be committed. There has to be a commitment by either Advocate General or Additional Advocate General. Can Mr. Gogoi come? Mr. Goswami, please ask him to come for a minute. He will take so that we adjourn the matter to that. Now, this is a very important matter for the reason that not because the petitioner is the daughter of a judicial officer, not for that. It's an issue which concerns all of us.
Yes.
Anyway, you please wait for some time. Let some senior law officer come. Mr. Goswami, we have called for you in your capacity as additional advocate. Now, please go through our order dated 31/3/2026. This is with respect to the interpretation of Section 143 of Assam Services Pension Rules of 1969. Now, in the family, the family included daughter, unmarried daughter, dependent unmarried daughter. Later, it was dependent daughter. By an amendment, it was extended to. Firstly, it was only for unmarried daughters. Now, minor daughters, then unmarried daughters. Now, divorced daughters, dependent. Now, there is why not widowed daughters? I think we will have to explain it that way. So the government, the High Court wrote to the government that, well, this should be done. The position is this. The major factor, the crucial factor to decide this would be dependency, number one. It will be subject to remarriage, subject to the finding of the fact that there is dependency and there is no other way of earning livelihood. So even if there is a family property, she is married in a family where she has been given the share in the family property, maybe this will not be there. But if there is nothing, then why not?
True.
So you just have a look at it. Please consider the request made by the High Court, or you take a stand. In that case, we are not asking you to concede. We will interpret it broadly. Because we have done it for divorced daughters, we'll do it for widowed daughters.
Personally, I will try to get it done, man.
All right.
Because I think similar view is taken in respect of compassion.
Because this does not appear to be very logical to us. The liberal doctrine should take in its fold.
Exactly.
But of course, it will be subject to the dependency, number one, and remarriage.
Exactly.
Because otherwise, we are not going to strain the government with respect to this. As long as she remains unmarried and dependent in her widowhood. Because the question is, there is an explanation. Who is a widow? Who does not have a husband at the moment. Now, unmarried,
position is
unmarried is same. She does not have a husband.
Widow and unmarried.
Divorcee also is same.
Being widow, unmarried and widow at per actually.
All right.
I'll get it done, man. I'll try to get it done.
As prayed for on behalf of the state, re-notify on. I give you 2 weeks. 2 weeks would be all right. Let the name of Mr. Goswami, learned additional advocate, be reflected henceforth in the process.
17(6). Item 16. Adjournment.
If nobody presses it, then we will dismiss the petition. Now, just circulating a slip. Have you circulated the adjournments?
Malat, it is from the other side.
So you just can't circulate and then leave the courts. You have to make a request. We may not agree to your request.
But here,
Jurisdiction question has to be decided first.
we have submitted our reply. There is no open record, I think. We have submitted our reply.
What do you want? You want to argue today?
Not now, at least 1 week time, he's suffering. So in that case, can it be possible?
No. Next week, if you don't argue, then we'll have to recall this order of stay. Because if we decide that we do not have the jurisdiction, see, idea about jurisdiction, territorial jurisdiction is more of an attitude than the law. See, even if there is some bit of it which is within the jurisdiction of Assam High Court, we will accept it. But the difficulty is that the order was passed in Delhi and you were served in Tripura. It matters not even if the tribunal in Gauhati has passed an order, but the appellate court would be Tripura High Court. Prima facie, this is our observation. It could be changed, whatever. But then you have to answer that. And then in that case, if you take time, we will grant you time because it's your case, but then we'll recall that stay order. That stay, if at all, it has to come from Tripura High Court, not from Assam High Court.
Next week.
Again, adjournment still can circulate. Julian, on behalf of the respondent, on behalf of the, well, 8 years, and on behalf of the appellant, let this matter come up for consideration on next week, Tuesday.
2nd June.
Next week, Malat, 26.
Yes,
Yes, lottery said next week.
next week.
26.
Interim may continue.
We are not saying that. It continues otherwise, unless we resigned it.
Obliged.
17. Item 17.
May please your lordship.
Yes,
This matter relates to that hybrid Madhava temple, Myra.
Now, we will not get into all that. There is a simple issue which says that a decree
Yes.
cannot hold the field unless there is something to the contrary. If there is a statute occupying the entire field,
Yes, my lord.
and a later statute has to be given preference.
True, my lord.
I think we'll decide it on that. Yes, Mr.
Yes, my lord, that's it.
Only thing, my lord, I'll implore your lordship to read my initial, my lord, the reply affidavit because the government had taken certain grounds. One paragraph.
No, government grounds will say. In just a minute. Now, where is the order of the deputy commissioner?
My lord, deputy commissioner's order, my lord, at page 132. There are two orders, my lord. One is at page 132, the other is at page 142.
Read the order at page 132. What does it say? We'll get to know some intervening facts.
My lord. May I
Yes.
read that, my lord? Seen and billed the judgment to be 12/6/2000.
Ah, where are you? Yes.
That judgment is at page 125.
What was the order passed in that PIL?
My lord, that
Can we have a look at that order? First,
my lord, your lordship will find that page 125. Ready. I'm sorry, my lord, 122, yes. 125.
you're right, 126.
126, 125.
Yes. Now, seen and perused. Yes, all right.
Also perused. Also seen and perused the application submitted by the President Secretary of Navo Telangana.
Special.
A socio-cultural organization of Hajo dated 12/7/2012 engaged to the Deputy Commissioner Kamru, in which the organization has prayed for the implementation of the Section 25A of the Assam State Acquisition of Land belonging to religious and charitable institutions of public nature at 1959 in Madhava Temple, Hajo, praying for management of the managing committee under the Deputy Commissioner Kamru. The report of the circle officer at Hajo Revenue Circle, wide letter number section as dated 14/9/2012. It is taken, it also taken into account the comments and views of the district and session judge Kamrup in this regard respect communicated by number section says is also seen and perused. From the letter of the district and session judge Kamrup, it appears that the management of the
This is one order. Which is the other order?
Madam,
Which is the other order?
other order, your lordship finds at page 142. Effective part, last but one paragraph, 143. In the instant case, although the present institution is receiving annuity from the state government.
Order, no?
Hmm.
Same order.
And has been reiterated.
Why you not seen and produced and seen and produced? Yes. There is no
Only
other part.
because that, only because of the, my lord, order passed by the civil court, my lord, that has not been.
Decree.
Decree of 1908, my lord. Before CPC came.
Have you said anything in our earlier order?
If your lordship clarified that aspect, perhaps the entire matter.
Just a minute. 28, no. 28, sir. 22.
Waiting for your material. Taken a paragraph to propose.
Take it up.
My lord,
What is response number 5 and 6?
5 is, my lord, the Dolui of the Hagir Madhava Mandir.
What is response number 5 and 6?
5 and
This Doloi.
my lord. Dolui and precedent
You
of
have not issued notice to them.
notices have been issued.
Have you issued notices?
They have appeared also, my lord. So, for example, list of non-papers only.
Doloi would remain a Doloi, no? Even if a committee is constituted.
No, in fact, no, that's why I was inquiring that your worship will kindly read one paragraph of my lord affidavit in reply, because the situation has changed now, my lord.
What is paragraph?
Paragraph
Let's
10
see your
in the, my lord, my lord affidavit in reply,
page.
paragraph 10 at page 148. Because I'll be failing in my duties if I do not point out my.
Yes.
That with regard to the statements made in paragraph 11 of the affidavit, which some deponent has no comments to offer and rely on
which
the statement showing so.
Paragraph 10.
Paragraph 10, my lord.
148. Yes, the statement made.
Then, my lord, in this regard, the deponent begs to state that management of Hygrid Madhava Temple presently is vested upon the managing committee. That is Hygrid Madhava Managing Committee.
Well, no, getting it at page 148.
Paragraph 10,
148 is
Paragraph
affidavit proposition.
okay. Affidavit in reply.
Paragraph 14.
Paragraph 10.
48?
No, it starts with
That we take out the statements made in paragraph 11.
No, it's about the references to paragraph 14. Anyway, you are referring to some other affidavit.
This is our
I think,
affidavit
his
in
page.
reply.
We have followed, you're at a different page. This is what you're referring to is paragraph, is page 155. Yes.
Sorry, man. 148.
Page 155.
Page 148.
148 is the earlier paging, the running
sir.
page is 155. Yes.
I'm
sorry.
sorry. That with regard to statements within paragraph 11 of the clean operation, the deponent has no comments to offer and rely on the and reform the statements made in paragraph 15, 16, and 17 of the PIL. In this regard, the deponent begs to state that the management of Hygrid Madhava Temple presently is vested upon the managing committee, that is Hygrid Madhava Managing Committee, under an old outdated scheme prepared in the year 1908 itself, with some subsequent amendment in the year 1938, which is formed under the decree passed by the Honorable Calcutta High Court entitled Suit number 3 of 1904. As per the said scheme, managing committee is headed by the Doloi, who is elected
Let's not get into.
by the borders of
So
Madhav
therefore,
Temple.
whatever happens, we are not concerned. We will go for the implementation of the Act of 1957,
That is fine, my lord.
25A. We have followed that. Mr. Chaudhary, please try and understand what the court is telling you. In that case, we'll have to issue notice to respondents number 6 and 7.
The restaurants have been issued notice, my lord. They appeared.
Have they appeared?
They appeared
There
earlier.
are names shown in the constitution.
Their names have been shown on the board.
Yes,
They
sure.
appeared.
Maybe they will come. Maybe they will come. Inform them. If you know the advocates, please have them informed.
A. Sharma, my lord.
Otherwise, we pass an order. See, what we are going to do is this. We'll talk about, you are not enough Prerna.
I'm not present.
You're somebody else.
Yes.
Now, then you come back as PIL petitioners. You come back as PIL petitioners again. Now, therein lies the technical difficulty that we'll have to avoid taking into consideration, because otherwise, the orders passed by the Deputy Commissioner on 2 dates, talking of 1908 decree coming in his way of forming a managing committee.
True.
Now, if that is under challenge, this comes under 226 general jurisdiction, not
That I
PIL.
understand.
In that case, this cannot be a PIL, because who are you? Then we will, question of locus will have to be decided.
That was raised in.
Just
the
a minute,
initial-
Mr. Shah. Now we are answering that. So we will take it up as a PIL in the changed circumstances, but we'll have to state all this, that we are not questioning the locus of Mr. Chaudhary for this reason. Because the temple has to be managed properly. The act is there. And the the deputy commissioner has taken an erroneous view of the matter. And what is the legal position that we shall explain? The only difficulty would be that your locus would be questioned by us because of this PIL. We'll convert this PIL into a general petition, but then in that case, it goes before a single judge. That's the whole difficulty.
So, my lord, then,
But the second time a PIL, there has to be a justification, no?
because my lord, this honorable court said.
So
that
you should have taken on board some members of the NAPRED. I think it would have been over. Who will get into all this? And then asking you to go back again, because this is primarily public interest.
My lord.
But then you're challenging the order passed by the deputy commissioner.
My lord, unless I, my lord, put it on record, my lord, and show a challenge to it, my lord.
Fortunately, you're not impugned it. We'll do it. Just inform the advocates, because they'll lose their job. The Dolois will lose their job. So therefore, they have to be heard. This is not public interest.
You see, this management is also by the state, isn't it?
Yes.
State,
Yes.
but not as per the act.
Not as per the act, but there is a scheme, my lord, and that scheme also needs some modification.
Inform the advocates, we'll decide it today only. If they come, we'll decide it today.
Right.
If not tomorrow, I'm just passing it over.
Right.
Let this matter come up for consideration. You type out that order, but don't have it signed by us. In case they arrive today,
My lord.
then we'll dispose it of today.
I'll try to inform.
If not, then it comes to.
Item 19.
My lord, I'm appealing on behalf of.
Now we are only contemplating whether to dismiss this appeal in the absence of the lawyer.
But
So they must approach the authority under the act 3H or something.
yes, definitely, my lord, there is a
So
provision.
if it
of
doesn't come, we'll
38.
dismiss it.
There's a law clearly says, my lord.
Did he come on the last occasion?
Yes, my lord.
No, did he come on the last occasion?
No, last occasion it was for order because
Miss M. Bora.
I was implemented.
Implement was granted on 18/3.
That is me, my lord, section 7, NSIDCL. Then order was there, my lord, today.
I think because of many cases being adjourned for some reason or the other.
No, my lord, that was
Oh,
due permission,
the
may I
absence of
submit?
the council.
Because not
Yes,
from
Miss
it.
Bora, you are Miss Bora.
Your Lordship, I'm the Das on behalf of SP Chaudhary. Kindly pass over the matter for timing and.
SP Chaudhary appears for whom?
For
For
appellate.
the appellant. But weren't you rather slow in approaching the court? We are asking you because you were approaching this side.
I got late.
The matter was about to be dismissed for non-prosecution. When you are entrusted with a responsibility, I mean, at least discharge that responsibility, come to the court.
Lordship, give some time. As my senior is engaged in another court, give some time. for-
Say on least to me.
As prayed for on behalf of the appellant and agreed to by the respondents, let this matter come up for consideration tomorrow. Tomorrow, how many matters are there?
Tomorrow,
Lordship,
may I prepare for at least today because tomorrow I'll be out of station.
The day after
That is
tomorrow.
urgency is there. Why?
Then day
Because-
after tomorrow,
My lord,
the day after tomorrow.
no, today I'll be out.
Today, we will not be waiting for.
Then- My lord,
After a week,
No, then try tomorrow. Then I'll just anyhow, because the urgency is there, there is not. Like,
tomorrow.
That is the. Please inform that Mr.
Item number 20. Sorry.
Anupam Sharma's mother expert, that is why my lord is not.
Okay, but he has to be heard. When will he be available? वो जो वो matter था when Mr. M.K. Chaudhary senior advocate, लिखे, we have heard Mr. M.K. Chaudhary, senior advocate for the petitioner and Mr. Sharma, and Mr. Sharma for the state. Mr. The learned advocate for that there is this court has been informed that there is a bereavement in the family of so and so learned advocate who represents respondents number 5 and 6. 5 and 6. Stop. Let this matter come up for consideration after 2 weeks.
Right.
After 2.
I think continue. 17.
Give the date.
10-6.
Inform him about the date.
I will inform.
Item 20.
This is the Anganwadi helper matter, my lords. Pursuant to my lord's last order, the state has filed the affidavit. Now, the affidavit clinches the entire issue, my lords. What the appellant has been saying all throughout, my lords, that has been stated here, my lords. Now, the writ petitioner who challenged my appointment, apparently, my lords, admittedly does not belong to the center where the vacancy is.
Shamnath, what is the is it center number 217 or center number 23?
23, my lords. The vacancy arose in 23. I'm a member of 23, my lords. That's
That we have clarified. It is center number 23.
Then it has to be set aside.
Lordship, I appear for BTC in this matter, my lord. I may be allowed some time to reconstruct the file, my lord. So
BTC is not even a relevant party.
He has no role. Now we will have to hear the other person, Sangeeta. We'll have to hear Sangeeta Holoi Barua. बोलिए then. There is no center. We have taken the affidavit of the state. You just can't come up with one line response. We are going to upturn the judgment of the learned single judge on this ground alone. So you'll have to argue.
Para 3, my
Mr.
lord.
Chaudhary, have you been served with a copy of the appeal?
State affidavit.
So therefore, they are the best persons to tell us. The person in 23 died.
Yes,
Therefore, the necessity of appointing.
vacancy arose.
And that's the only ground for setting aside the appointment of Mr. Mohanta.
One of the evidence of the government, they have given the
Unless, and have you also clarified that there was vacancy in 17, in 23 and 217 both?
To the 217, there's already an incumbent helper, my lord.
We are asking.
But in paragraph
Para 3.
of our affidavit, we have clarified, page 207, that 217 Pazipara Pool Side Anganwadi Center is a different Anganwadi Center under Nalbari ICDS project, where Podumi Bejburo is serving as an Anganwadi worker, and the name of this Anganwadi Center is not mentioned in the advertisement dated 18/2/2019.
This is no statement. You should have said that the advertisement was issued with respect to Anganwadi for this center.
Yes, Mr.
That has been stated.
Yes, sir.
That you have stated.
Yes, that advertisement was published by the respondent number 6 on 18/2/2019 for filling up the vacant post of Anganwadi worker in Purva Pazipara Poop Anganwadi Center, which is actually the number 23 Purva Poop
Then,
Anganwadi
Mr.
Center.
Chaudhary, what right do you have? You have to make way for him.
the advertisement, we have to go with the advertisement.
Suppose advertisement says nothing and there is a confusion. What do we do now? Now, in that case, the learned single judge should have looked for it. With the clarification, can we allow you to continue there? That's the whole question. You're right. If the advertisement was misleading the learned single judge before, questioning somebody's appointment or engagement, I call it engagement, not appointment. Questioning somebody's engagement should have sought a clarification. If that clarification is not sought and order is passed, it has to go.
And still did not file equity.
And you still will not ask.
With a very short reply to that, Manoj, in the village area.
Mr. Mohanda, please, you hold back for a minute.
I'm sorry, Manoj.
That time, were you appearing before the single judge? You should have asked for this.
We clearly stated, my lord, lots of
What
we are,
you said that
affidavit in opposition.
Just a minute, it's only the state which can certify if the absence of the advertisement being clear enough, but acted upon, an appointments taken. It was meant for which center, that has to be clarified with the state.
And the review was filed, my lord, that we have pointed out that the vacancy arose in my center, not, that is not considered, my lord.
Because it was taken to be a re-hearing of the case.
Yes.
So in that case, Mr. Chaudhary, take your call. We are deciding the matter. You want to argue, you can argue.
Your Lordship may kindly come to the memo appeal at page 76. This is the list of accepted applicants for interview under the Norbury ICDS. 76. It's 76. Now, your Lordship will find the name of my client, restaurant number 1 in the appeal. My lord, at serial number, my lord, the clause is Porua Pajipara Poopside. The name of the appellant appears at serial number 1. My name appears at serial number 4. So both the applications were accepted. Now, my lord, so this is the same center. Thereafter, your Lordship will kindly come to page 78. List of my lord, not accepted, Pazipar Poopside.
And where is that? This is center number 217.
23.
This is 23.
What is this? Applicants.
Yes. And where is center number 217?
There was no selection for 217.
And you are a resident of 217.
My lord, the
You reside in 217 jurisdiction.
that we have not stated anywhere, my lord. I'm sorry.
The record is there, my lord. Lordship may kindly peruse page number.
Just a minute. He is not prepared. He was not even ready for an argument. We are forcing it out on him.
Now, my lord,
Now, Mr. Chaudhary, we can give you time till tomorrow. Because this concerns Anganwadi, which is a matter in which we are very loath to interfere. But here, because something has happened which will go unremedied if we don't interfere. The single judge ought to have taken care to have found out that the advertisement pertained to which center. So just have a look at it. And if you can file any document to say that, well, the contention of Mr. Mahanta is not correct, that I don't hail from area covered under 23. That can be your only response which will cut ice, otherwise nothing.
my lord, I understand, my lord.
Which document were you referring to, Mr. Mahanta?
My lord, this center number, my lord. Lordship.
No.
Yes.
Her domicile.
Yes. Her, the Anganwadi centers, my lord. AWC have their own surveys, my lord. And in this survey, she falls in 217. That is appended in.
Where is that document?
Yes. My lord would just give me one page number. Yes. Just a moment, my lord. My lord, come to page 172, my lord.
And it's in vernacular, my lord, Justice Chaudhary may have a look.
Chaudhary will look at it.
Yes,
too.
170.
MK Chaudhary,
Which-
that is the document. you-
Which space? 172, my lords. শিশু বিকাশ সেৱা পৰিয়ালৰ সবিশেষ. The Anganwadi center number is there, 217. Who is the current Podumi Besbora helper? And if my lord turns the page, number 2, Srimati Sangita Haloy. I'm so sorry, my lord. Page 172, my lord. 172. 172 of the appeal number. In vernacular, there's a type copy, but my lord will have a look at the vernacular. Center number is 217. The Cormi name is also there, Podumi Besbora. And if my lord turns the page, my lord, next page at serial number 2, name of the respondent, Sangita Halera. I've seen. And in fact, while appearing in the writ petition, my lords, the writ petitioner had submitted, my lord, he had accepted my submission, which said, my lords, that I belong to 23 and she belongs to 217. Yes,
Mr.
that was-
Chaudhary,
yes.
if you want to concede to this, all
There's
right,
nothing-
we will dictate the judgment. If not, come back to us tomorrow.
6 years she's been tomorrow, man.
I mean, what is there in that page, 172? If you want to dispute that, all right, otherwise. As for, on behalf of the respondent, let this matter come up with a solution tomorrow. Yeah, day after tomorrow.
Day after. Deeply obliged, I'm very grateful.
For hearing item 21 and 22.
We'll take it up in the last.
Last second, my lord. My lord, on the last occasion, asked for a note, my lord,
You're
about 7 pages. I couldn't complete it in 7 pages. It took 18 pages, my lord. But everything is there, contradictions and everything. I have furnished that.
we're done with, and Mr. Kamar, you had also filed one. Mr. Kamar, you had also filed your.
Yes.
All right, so we'll call upon you. Maybe we'll finish with all the
My,
list and then we'll take up the hearing
my lord.
today.
We have another date reference, item number 25 and 26, my lord.
That will adjourn. We'll first hear
Tomorrow.
this one, 21 and 22.
No, Lord, no,
You're
Lord.
happy or unhappy? All right, we'll take one appeal today. The rest we will give time. Correct. We'll try and conclude it. You come after lunch
My,
from 2.
but at 2, my lord, a matter has been fixed in another court. I'll do it my 5 minutes to take my, I'll come back.
Doesn't matter, we'll reassemble at 5 past 2.
Am I? My lord, bless you.
Much.
We'll get up for a while.
No.
Then ask, call out 24. If the lawyer is not there.
Item 24.
Yes.
This appeal against.
Just 1 second.
That 25 and 26 popular.
Ms. Bornali, you're appearing in item number 25 and 26.
Yes, my lord.
Who appears for the appellant?
Ms. B. Sharma.
Just inform him.
Inform her. No, she is the lady.
Huh?
Inform her.
Sorry, inform her.
Will inform. He was here, madam.
She was here.
Yeah, but.
Inform her that we take up this matter next week, next Tuesday. Because we'll be completing one.
My lord. Oh, shit. Obliged.
Here. Let this appeal, let the appeal to the firms be listed in priority for hearing on.
26th of May.
It's fine.
Yes,
This appeal, the appellant was initially appointed as a CIS constable, madam. While he was in probation, madam, he develops a certain heart ailment.
yes.
While he was in probation, he developed some heart ailments and he has undergone surgery. And subsequently, he came under the medical condition shape 2, So, ultimately, the probation period was extended and he did not come to the shape 1 category. So, his service was terminated. I have prepared some list of dates.
Let us see the CISF rules in 2001. Rule 25 and 26. Who appears for CISF?
Rule 25.
Now, was there not any way of accommodating him in a non-police job?
Yes, because of the appeal is pending, that's why that observation, my lords have given an observation. That party's lordship not acted.
No, you said that you don't dissociate him from the service, but I mean, acquiring disability in service, relevant benefits you can give. That is what the singer just said. But you removed him from service, no? Now, not because of his fault. Of course, you showed compassion. You got him treated. You extended the probation period 4 times.
4 times.
We appreciate that.
Double that.
But then he is now not so unfit as not to be retained in service. What do you have to say to this?
Paragraph 12 lordship, we are
Paragraph 12 and 13.
paragraph 12 and 13 lordship. 13 lordship, it was negated by the honorable court lordship. 13 part negated lordship. Paragraph 12 part in
11.
Thirteen part negated by the honorable court lordship. Paragraph 13. It is the reason.
Can you have some instructions whether you can reconsider this stop? We are not.
I can. Medical boy, lots of things. Lots.
we'll have to undo this paragraph 30.
Lots.
Because the single judge has given a reason that
Yes.
doesn't appeal to us.
Lots.
Now, instead of doing it, because this will open a floodgate,
Lots.
if we undo this,
Okay.
the reasoning given by the learned single judge,
Lots.
then perhaps you'll have to give a reinstatement to all such persons in shape two.
All persons.
So we will not do that.
Lots.
But here, see, it was in the beginning,
Lots.
and this was a peculiar disease which may have aggravated. It is some kind of murmur, coronary murmur.
Lots.
Now that's because it is a precursor to ischemic heart.
Lots.
There are some scaling inside lungs which causes that murmur.
Lots.
That is precisely for the reason of somebody having suffered pleurisy in his early days, which must have went unnoticed. No difficulties, but the liquid may have, the liquid would not have been aspirated, so it dries up inside the lungs and causes flakes. And that's my understanding, limited, rudimentary understanding of medical thing. It doesn't make him faint or something. So he could be given that job of a runner or a store in charge or a mailman. I'm giving this logic, read paragraph 13 again.
13, I have
Read it.
Lordship. Mr. So-and-so learned senior counsel by referring to the implications of the provisions of lower medical category by the medical board, the CIC, makes a submission that because of the lower medical category, the petitioner can be placed in some sedentary duties like runner, storeman, manager, etc. We are unable to accept the said submission on the ground that the lower medical category of the petitioner is not in course of any duties that the petitioner may have done as a constable GD, but because he had suffered the lower medical category because of the illness. Providing alternative position of the to the personnel in case of a lower medical category would have to be related to the aspect that the lower medical category was as a result of the person's concerned performing his duties in the force, and such duties had resulted in his being reduced to lower medical category.
And what was the necessity of having first and second medical boards after he was found fit to resume his duties after his open heart surgery? What was the reason?
It's a loss of routine medical.
Compulsory. So it says it placed him in shape 2.
Shape 2 loss. Even loss of
Mr. Gogoi, I think there is certain circulars and what you call some name, I forgot it.
Yes, yes.
Prescribing this,
loss.
how to and where to put in these cases.
Because we are in the probationary. If he is the regular post lossy, then if he is promoted, then he can revert back to the original post lossy. In 25 itself, that provision is there also. Section
Just a minute.
rule 25 also.
Where is the provision with respect to shape 2 medical persons being taken into sedentary jobs? And where is that limitation that it has to, the medical condition should have come to the person only during duty?
Lordship. It's in page 175, Lordship. Page 175. Lordship.
What is page 175?
170 of
I'm
the
asking from the rules.
170 of the there's a circular is there. Lordship.
Circular.
Circular is there. Lordship.
75.
Serial number kilo.
Just
Sorry.
the timely assessment of performance and confirmation. Not shape one.
There is some other circular. I
I don't think this circular, this does not prohibit.
There is specific.
Yeah, some records there is circular. Shape one, shape two.
I think Assam.
Assam records. So shape one, shape two.
This information as done by the DPT or the institution. Followed by DPT. Since for all the posts in TFDF or shape one medical category have been made mandate. By way of them which is regulated out. Shape one category is preferred naturally, but shape two, where is the bar? That he cannot be given a sedentary duty as has been held by the learned civil. You have to treat him like a person with disability, otherwise. No benchmarks, nothing, but then it was unfortunate, he lost the duty, he joined. He's ready to serve, he's completed his probation.
Some of the document,
When was he removed?
medical document is also there.
When was he dissociated?
He was disassociated lordship on 4 to 14 lordship, page 142 lordship. 14. 4 to 14.
You're out of job since 2014.
No, my lord, my lord, repetition was pending.
We are talking about.
My lord, now, my lord, out of
You
record, my lord.
have misunderstood our question.
My lord.
You have misunderstood our question.
Yes.
It's not for testing the time limit. I mean, no limit.
Yes, my lord. Yes.
We are only thinking that after 12 years, do we ask him to be taken in?
My lord, out of record, I am submitting that he is now working as a security guard, my lord. My lord, his financial condition is also very bad. He is, and my lord, there is certificates issued by some gym, my lord, regarding physical health. So, my lord, he is now, my lord, he is fit. But thing is that, my lord,
12 years, why? When this order was passed?
this order was passed on 6/9/22.
And what benefits did you get?
Nothing. Lordship, that 12th part we are not, till now we are not active as because appeal is pending, Lordship. That is the reason, Lordship.
And this appeal is which year?
22, Lordship. 22, Lordship. After the passing of the judgment, Lordship. Even
Just
Lordship,
take instructions.
Lordship, I will obtain.
After a fitness test again,
Lordship.
if you can put him in sedentary.
Then-
After 14 years, he can.
Yes, that can be.
14 years, Mr. What is his name? Mr. Kolita, after how many years?
14 years. No.
After 14 years.
12 years.
12 years. We can't issue any mandamus. It's on their sweet will. We'll ask them, we'll make a request, let's see.
Yes.
We are not happy with the reasoning given in paragraph 30.
Lordship.
Because there has to be a circular prescribing their powers of retaining somebody in service.
And my lord,
If it comes to shape 2,
in my lord, paragraph 8 and 9 of the judgment, one single judge specifically observed that section rule 25 and rule 26 is not applicable in case of present petitioners.
Yes, Mr. Gogoi is not even arguing that he has
Yes.
shown us that circular. That circular in a roundabout way says
Yeah.
that shape 1 is compulsory.
Yes.
It has to be taken into account before confirmation.
Yes.
So it doesn't say that shape 2, you throw them out,
Yes.
dissociate them. No. But
Yes.
then he is right to that extent that reading it, this comes through the back door. It says if it is mandatory for a person to be confirmed to be under shape 1 condition of health,
then the necessary corollary is that shape 2 is to the exclusion of some shape.
Yes, my lord, my medical board first constituted on 3/10/2012.
We disputing those facts. No, we are not.
Then, well, from then itself, my lord, that they suggested for sedentary use.
At the time, they have suggested that was argued also on behalf of the
Yes,
appellant.
yes.
But then that was rejected by the learned second judge. Now, we would have upturned that judgment, but for passage of 12 years,
We don't know whether.
within which time you have been working, even if we do that, he will take an undertaking that you will not ask for any back wages, nothing of the kind.
My lord.
And
Nothing.
subject to.
Yes, my lord.
And subject to his fitness.
Even lordship, some of the document, medical report says that lordship disability was contracted in service lordship. That part is also there lordship. Page 138, my lord.
Report में बोलता है तो it was clear in the fact. Which phase?
Page 138 lordship. It says that lordship was the disability.
Paying visibility pension and all for that finding.
No, that particular.
But you can't say both things.
No, I
Just say both things.
just indicate lordship the medical report what it says lordship.
He's not saying that.
Take instructions.
Lordship, I will.
We can upturn the single judge's
Lordship.
judgment. We will upturn it, but how do we answer this passage of 12 years? Take some instructions and
Lordship, I'll.
My lord, the appellant will give the undertaking, my lord. He will not seek for my lord, back wages.
the appellant. We have heard Mr. N.K. Kanikal, learned advocate for the appellant, and Mr. K. Gugoi, CGC. The appellant was selected as constable general duty, general duty in CISF under the Central Industrial Security Force under the Ministry of Home Affairs, Government of India. He was appointed after he came out successful in written and physical efficiency tests, as also a medical examination. He joined on probation sometimes in February 2010. And underwent training. After the basic training at the Recruitment Training Center in Odisha, he was posted in a unit at Nuclear Power Corporation in the state of Karnataka. During the probation period, he had undergone an annual medical examination in the year 2011, where he was diagnosed with a systolic murmur, a heart condition which later required him to be operated upon for valve replacement. So as a result of such illness, he was put in shape 2 category, which is a category for lower medical fitness level of an employee. With such categorization of the appellant as shape 2, he was referred to a cardiologist. And under medical advice, went for open heart surgery as referred to above for his valve replacement. in 2012. Post-surgery, he recovered and was declared fit to resume his normal activities. This report was acted upon and the appellant was permitted to join the general duties at some CISF unit. Subsequently, 2 medical boards were constituted to assess his condition. The first medical board which assessed him placed him in shape 2 and also recommended for sedentary duties like a storeman or a messenger or any other similar post. However, the second medical board in 2013, the second medical board also in 2013 reaffirmed the shape 2 medical level of the appellant and also noted that this disability was contracted while in service. However, the board recommended that he was fit for physical training and other duties involving sedentary roles. Despite this, the appellant grieves. His services were terminated in 2014. On the strength of a circular making it mandatory for taking into account shape 1 health of the constables for confirmation. The reason assigned for his being dissociated from service was his medical unfitness for permanent appointment. The appellant, however, admits that the employer/CISF had extended his probation period for 4 times, but submitted that dissociation ought not to have been. But dissociation from service was a step which was not warranted, was a step by the employer which was not warranted, especially in view of the suggestion of the second medical board that he was under fit medical condition to take up other roles, take up other assignment with somewhat sedentary role. The termination of service of the appellant was questioned by him before the learned single judge by WPC number 1554 of 2014. Who upheld the dissociation of the appellant from service, but directed that he be treated under laws applicable to personnel acquiring disabilities in service, entitling him to relevant benefits, and he be not treated relevant benefits. With respect to the appellant being placed in sedentary roles as he was in shape 2 health, the learned single judge observed that since the medical disability was out of sickness, which was not attributable to his professional duty, comma, he could not have been considered for such placement. Prima facie, we find no reason to affirm, we find no reason to validate such an observation in the absence of any clear policy of the employer slash CISF of completely dissociating a probationer on grounds of medical reason, on grounds of his being in shape 2 medical level, shape 2 medical fitness level, and not offer him even sedentary roles of runner or house guard, storeman, or messenger, etc. So in this context, we have asked Mr. K. Ugoi, learned CGC, to take instructions in the matter, whether the appellant could be reinstated in service, but only subject to his present fitness level. While saying so, we have also taken into account that for the last 12 years, he has remained dissociated with the force, perhaps only account of the pendency of the writ petition as also the appeal. Because of such pendency, comma, even the benefits which were even the benefits which were permitted by the learned single judge, which were suggested by the learned single judge, could not be given to the appellant. Let this matter come up for consideration on
Yeah, the police,
after 4 weeks. Take instructions.
Okay,
I don't think it's a correct reasoning.
I'll do it.
Shape 2.
I-
He can be a runner, he can be a guard.
Even the post medical would recommend it. I will remove.
Third June. Item 27.
Let's be clean for your lordship.
Just a minute, give us a minute.
Lord.
Just read that extracted portion from Biralal Dole.
Lordship,
It has been extracted in paragraph 7.
Lordship, paragraph 7 of the.
Just read that, Mr. Thakur.
Lordship. The issue involved herein is as to whether the petitioner being appointed as the assistant project engineer would be entitled to AICT pay scales with effect from the date of his initial appointment, taking into account that by notification number so and so dated 7/2/2000, the government of Assam had extended the benefit of its AICT pay scale to the faculty members of the Polytechnic institution with effect from 1/1/1996. This court has perused the press release enclosed as Annexure 17 to the writ petition, wherein it has been mentioned that in respect of diploma level technical institution, it is only the teachers, librarians, physical education personnel in the diploma level technical institutions who would be covered under the AICT Act. As has already been mentioned, that cadre strength of diploma level technical institution consists of one director, principal, in addition to each department having one head of the department, which includes one lecturer, one senior lecturer. It further appears from the notification dated 7/2/2000 and closed as Annexure A to the affidavit filed by the Department of Finance, whereby UGC AICT pay scale to the teachers of the government polytechnics of the state was extended with effect from 1/1/1996. In the said notification, the posts have been specifically mentioned to be post of principal, head of the department, professor, lecturers, selection grade,
No,
non-tech.
tell me one thing, Mr. Gogoi. Now, this reasoning appears to be very specious. Specious means it's, they are not able to get any. Now, did you come up with any proposal that, assistant project engineer would be equivalent to a lecturer? And he would get a salary which would be in terms of the AICTE Act. Therefore, he will get an allowance of AICTE.
No, Lordship.
Did you make that?
No, Lordship.
No, you have.
See, it is regarding AICT scale of pay, it is not there. Instead, scale of pay, there is there. It is there, Lordship.
So that notification never came.
Lordship.
So what was the logic of saying all this?
Lordship, yes, because Lordship, in the cadre position of the diploma level
In
institute.
that case, yes, Mr. Thakur.
Lordship will kindly come to the earlier order, Your Lordship. In the first round of litigation, Your Lordship will kindly come to page 68.
Something given direction to Additional Secretary Government of Assam to consider.
No, Your Lordship, to consider in the light of para 6 and 7 of that particular judgment. Your Lordship may kindly come to
No,
page
judgment
69.
we may say anything, but
Lordship,
unless it is backed by any memorandum, any decision by the government that well, assistant project engineers would be treated equal to the lecturers and they will get the same pay scale. If you say this, we will ask you to be paid from 1992.
Your Lordship may kindly come to para 6 and 7 for a moment, Your Lordship.
Yes, which paragraph?
Page 69, Your Lordship. You can put it.
69.
Page 69. Accordingly, when the notification dated 2/2/1995, Your Lordship,
1 minute.
Lordship,
Yes.
Lordship,
Paragraph?
there are 5, 6, and 7, Your Lordship. Lordship. Accordingly, when the notification of 2/1995 is read conjointly with the communication of 8/6/2000, it transfers that the project engineers are given AICT scale of
Where does he find it?
Lordship may kindly, that
Two ninety-five.
your,
It is two ninety-five.
your Lordship will kindly come to page 46.
46%.
In exercise of, this is your Lordship. ROP, your Lordship. In exercise of power conferred by the provision of Article 309 of Constitution of India, Governor Assam is pleased to order that following further amendments shall be made to Schedule A to the Assam Service Revision of Pay Rules 1990, published in the extraordinary issue of Assam Gazette so and so. Under the head of Education Technical Department, below the subject Polytechnic, the existing entry in column 3 against the project engineer shall be substituted by following new entries, column 4 against the project engineer and the assistant project engineer. As special pay with effect from so and so is admissible in the line of lecturer, technical, polytechnic. Now, based on this, your Lordship, project engineers are given the benefit of your Lordship, AICT pay, your Lordship.
I don't find that.
If no one recommends that it they get AICD scheme.
No, your Lordship, so far as project engineers are concerned, it is there. That your Lordship will get it. Page 57. Your Lordship may kindly come to page 57. Similar manner, project engineer and assistant project engineers are created, your Lordship. Page 57, your Lordship may kindly come. In inviting reference to the above, I am directed to inform you that the officers holding the post of training cum placement officer project engineers in Polytechnic are eligible to get the AICT scale of pay. All these officers are posted either on transfer or by promotion, which are equivalent to post of HOD, your Lordship. On the Honorable Single Judge, your Lordship, in the first round of litigation, your Lordship, based on this, in a similar manner, project engineer and assistant project engineers posts were created for the polytechnics of different polytechnics, your Lordship. Your Lordship will get it at the annexure, your Lordship will get it.
No. Into some accordingly when the notification of 2/95.
Lordship.
2/95 directly the communication daily to 6/2000, page 56. Project engineers again as it will pay at pay of the HOD as
If Lordship allow, I must clarify page 57.
Mr. Gogoi,
Lordship, page
where is your affidavit which says that they are not entitled to be paid AI scale till the time they join as they are posted as lecturer?
Lordship, we have filed, in this case, they have not filed any affidavit. We have filed the Bialal Dole Express, Lordship.
You have filed?
Earlier cases, Lordship.
No, earlier case or no case, you tell us, make a categorical statement that no assistant project engineer would be entitled to AICTE pay scale. Then in that case, we dismiss Mr.
Well, Lordship, my lord, just I point out page 57, I clarify, Lordship, page 57.
Do no notification, ask them. You just make one statement that AICTE pay scale, they are not entitled.
No,
They are entitled to only lecturers in the Polytechnic College
Lordship.
are entitled to AICTE. You say that.
Lordship, I will file before that, Lordship, just page 57, I clarify, Lordship. Page 57, Lordship, the project engineer was given the AICT scale of pay as because they are originally the HOD of the Polytechnic, Lordship. They are transferred and promoted to the project engineer post, Lordship. That is the reason, Lordship. We are also transferred, your Lordship.
No, what Mr. Gogoi is saying, this is meant for only those persons which are a head of the department, the
Lordship,
polytechnics,
Lordship.
and transferred to the
Transferred as a project engineer. Project engineer.
That is what is.
That is the case. Not what people Lordship.
Even
They
lordship,
have
that,
submitted before
that like very specific lordship.
and your lordship will kindly come to page 60.
Just a minute. Holding the post of training from patient doctor. Yeah, I'm directed to inform that the officer only in polytechnics. They should also be posted in polytechnics. And the program there to clear the case of polytechnic, subsequently polytechnic of growth, so therefore they will become the lecturer. So we said who and the learning single just interpreted that this HOD to be that though they are transferred, they are equivalent to HOD.
Lordship.
And you are saying those which are HOD shall only be entitled for it.
Even lordship, the persons who are as a senior lecturer lordship, senior lecturer was appointed as a project engineer lordship. Here petitioner's case is that he was directly appointed as assistant project engineer lordship. Not from the lordship, technical education department lordship. Not from the lordship, the diploma level institute lordship. It's a centrally sponsored scheme is there lordship. That is the reason.
Is he a diploma holder or degree holder?
Lordship.
I am eligible for lecturer.
He is eligible for lecture. That's why we have from 2003 onwards, lordship, when the centrally sponsored scheme was.
But what? You said that.
But your affidavit is not clear that they were initially appointed against a project. Therefore, their scale was something different. Subsequently, this project discontinued. Therefore, they were transferred to accommodate themselves in other polytechnics. Therefore, from that date, you have given them scale of it. This is your case.
This is your case. This is our case.
Now your lordship may kindly come to page 60, your lordship, AICT notification. My past services, they cannot reach them, your lordship.
So how you put your affidavit?
Lordship will try.
This also your lordship may ask them to clarify, your lordship, page 60. The counting of your qualifying services for career advancement. My past services all together will stay with you.
As for Thakur letter, senior advocate for the appellant, and Mr. K. Gugoi. You're assisting him or you're separately? Mr. K. Gugoi assisted.
Mr. A.R. Tarvinda.
Mr. K. Gugoi assisted by Mr. A.R. Tarvinda for Higher Education Department. The appellant has not been paid. The appellant has been paid the AICT pay scale only from 2003 when he was adjusted as lecturer in mechanical engineering at Bongaigaon Polytechnic in the year 2003. The appellant wanted the same scale of pay from the date of his initial appointment in the year 1992 on the post of assistant project engineer. The contention of Mr. Thakur, learned advocate for the appellant, is that the government of India had introduced a scheme called Community Polytechnic Scheme under various posts like project engineer and assistant project engineer, which posts were created in Assam Polytechnics. The contention of the appellant is that the post of assistant project engineer was treated as equivalent to lecturer in terms of qualifications and responsibilities. Next, the appellant was appointed as assistant project engineer in the year 1992 through Assam Public Service Commission. Later, when the post of assistant project engineer was abolished, as noted above, the appellant was adjusted / appointed as lecturer in mechanical engineering at Bongaigaon Polytechnic in 2003, from where he was transferred to Gauhati Engineering Institute in 2009, where presently
he has already retired.
Where the appellant served till where the appellant served till his superannuation. He claimed AICTE pay scale from 1992. The appellant claimed AICTE pay scale from 1992 onwards. And the arrears of pay, which was refused. There were 2 rounds of litigation by the appellant. But ultimately, the claim of the appellant was rejected by the learned single judge by the interim judgment, wherein the reference was taken of the case of one Biralal Dole in Biralal Dole versus State of Assam and others. In which case it had been held that in the event of a person being adjusted and posted as lecturer of mechanical engineering on the abolition of the post of assistant project engineer, he would not be entitled to AICTE pay scale for the period that he served as assistant project engineer. As such pay scale is only given to project engineers who are head of the departments. Are given to project engineers who are the head of the departments of polytechnics, and not to any assistant project engineer, and not to all assistant project engineers who ultimately are adjusted against the post of lecturers in polytechnics in the state of Assam. The affidavit, the circular in that regard does not appear to be clear to us. Mr. Gogoi, learned CTC shall put in Senior Standing Counsel, Higher Education Department, submits that he shall file the required affidavit in opposition to the memo of appeal by the next date, with a copy served advance, with an advance copy to Mr. S. Thakur, learned senior advocate for the appellant, for him to rejoin if being necessary. List this matter on after 2 weeks.
Two things, Your Lordship. First, Your Lordship, we have prayer for cash promotion also that has not been reported by
What is?
cash promotion.
Please decide on this. Yeah, let this be
And
discussed.
secondly, Your Lordship, that I have not been adjusted, Your Lordship. I have been transferred, Your Lordship. Specific, that adjusted word is not there.
The post was abolished.
Abolished, then I am.
Once it is
transferred on-
abolished, you
in
are
pub-
adjusted.
in
So we
public
have to be
place.
careful in saying adjusted / appointed.
5-6.
Deeply approved.
So
Very good.
12 June. 12 June.
Yes.
Deeply obliged.
Item 30 and 31.
Yes.
Lordship. The side is not here.
There's, in all, there are few advocates who get very happy with the other side of the. Chakravarti is one of them. Huh? You are happy or unhappy? Again, Mr. B. Chakravarti, learn standing up, learn. Yes,
She's here, okay.
Lordship, my seniorism led.
who is your senior?
S-Nat, Lordship.
Hmm?
S-Nat. Lordship, matter may be take up as a last matter.
No, we have taken up, we will be taking up on death reference matter. We put it next week then.
Okay, Lordship.
Yeah, both the appeals, both the writ petitions were taken up together. Mr. B. Chakravarti, learned CGC is present. A prayer for Passover has been made on behalf of the respondent on account of unavailability of Mr. S. Nath, learned advocate, who has to address this court. Seeing the heavy board today, the prayer made on behalf of the respondent cannot be exceeded to. Let both the writ petitions be listed for consideration on sometimes in June.
18 June.
18. Always Lordship.
Yes.
Item 32.
Yes.
Not very much.
Yes, Mr. Singh.
The termination, my lord, is in fact, my lord, they have mentioned that I have been released from service because of expiry of date.
That's what
Term.
that's what it appears to be
Lordship, my lord.
from the letter.
Lordship. But it is in fact not.
Why do you want us to lift the wheel? Why do you want us to pierce the wheel rather, not lift?
This court before the Honorable Single Judge already, my lord, lifted the veil. And an order was passed accordingly, my lord, affidavit has been filed. And they have detained. Now, for a moment, my lord, even if your lordship do not go into that aspect, whether, my lord, the service condition, either by the agreement or by the, my lord, appointment order or the regulation provides that the appointment, my lord, comes to an end on the expiry of the term in the, my lord, agreement.
I didn't follow this argument. Mr. Saikia. We understand, and this is the accepted proposition. Of course, it cannot have a legal validation that you don't make it continuous for your own advantage, which is very exploitative. We understand. You means employer. The employer does not make it continuous only for the reason of preventing the employees to seek some kind of benefit because of the regularity. Now, every time there is a extension after say 10, 15 days gap. So this regularity chain is broken. Nonetheless, they get regularized. They get a further lease of life for a particular period. Now that apart, that question you have not raised. Here, the lease expired. It was not renewed. They find it very convenient not to renew it again. For very many reasons, you may have faced a criminal prosecution, you may have faced a departmental inquiry, whichever. Now they don't want to do it. Can we force them?
This service condition is governed by regulation. The regulation speaks otherwise.
What does the regulation?
Continuation is kind of a rule. And this regulation. The regulation I have already submitted before the court, perhaps it is there on the record. It's a service regulation. and financial regulation 2003.
Where is that? Here, service regulation. Which paragraph? It is a committee, it's a mission, it's a project.
8.
Paragraph?
8, my lord, Lordship will tell me first, Lordship may come to paragraph 6, my lord. A person holding a service on deputation or attachment shall be liable to revert. My lord, they
Paragraph
all
6. General conditions.
general condition,
The
Lordship
mode
may,
of recruitment shall be on contract for a specific period for placement of so and so.
Lordship. My lord will say 7B. First, my lord. 7B, any person engaged on contract service for a specific period under an agreement shall also be liable to be discharged, released from Assam as if he fails to discharge duty satisfactorily and as per terms of the contract. Now continuation, your lordship, clause 8 is the very important, my lord. A, after successful completion of the term of agreement of deputation, mission director will follow following procedure and arrange for continuation of employees on deputation attachment and further engagement of employee on contract in mission service. Executive Council will be informed once in a year regarding deviation made, if any, from the prescribed procedure for continuation. Number and category of employees who have been allowed to continue in mission service. Now, what is the procedure followed? Lordship may come to next page, page number 11, serial number 8, serial number 42. That is my post. So there, what is to be considered, my lord, will see collection of self-assessment report, review and comments on self-assessment report by DMC and concerned SPO, SPCO, decision on continuation of the employee on deputation attachment and further engagement of employee on contract basis in mission service by MD. So self-assessment will be there, that will be reviewed by the reviewing authority, and ultimately the managing director will, my lord, take a call whether to continue or not to continue. And this is, my lord, discontinuation is an exception. It has to be reported to the my lord, the executive, my lord, council. There is nowhere, my lord, neither in the appointment order or in the agreement, it says, my lord, moment the period, my lord, expires, my service will be, my lord, come to an end. Rather,
It's difficult to accept that argument, Mr. Sakya.
Yes.
Very ingenious argument, but then, in fact, we will not say ingenious. It is a very tenuous proposition. It cannot be accepted. A plain reading of the regulation also does not give you the latitude to argue this. That's for clear.
no, they themselves has admitted, my lord, in the, my lord,
What do they admit? They're not going to say that they're not admitting a regulation. We read regulation differently. Regulation says that it is always on contract, number one. Number two, the contract is extended. If it is a deputation of a government servant, it shall be arranged that the deputationist again goes back to the place and comes if the parent department leaves him. And any change in the process shall be communicated to the executive council. So change in the process of what? Of appointment, of continuation, of anything. So they don't change it. Where is the embargo on the employer of not renewing the contract? Don't put it differently, Mr. Sakya. You have done it for your client, but then we don't accept that proposition. Where is you are saying where has it been written that after the expiry of the term of contract, his services should be immediately dispensed with? No, it cannot say that because there is a provision for continuation. That provision has not been invoked. That's the question. So therefore, in fact, the other side will argue, and it would be an endless argument, that where is it written that every time a person's contract expires, it must be renewed? So this is what in English language we call whataboutery. What if this happens? What if that happens? This will not beg an answer. Of course, not from the bench.
No, that's true. What I'm on, reading this provision and the affidavit, it makes it abundantly clear that all the services are
So
continued.
there are two things. We are looking at only two broad facts.
Right.
Broad facts. Not, minor facts here and there.
Right.
Two big elephants are standing in your way. One, your service was contractual. Contract has expired. Be all in and all.
Well, my understanding of clause 8A, after successful completion of the term of agreement or deputation, mission right.
It is only,
follows.
Mr. Saikia, we need not enter into any debate with you. We are not engaging in any dialogue, but we are telling you, you're reading it differently. This is so far as the provision granting the latitude to the employer with respect to continuation of the contract. It does not give you any vested right that you must be continued on contract. It's as simple as that. I mean, if we read it anything differently, we would be doing injustice to the regulation, to the wordings, to the English language employed in the regulation. We understand that. Your argument, in fact, should be that on face of it, it does not appear to be stigmatic, but it is stigma because I suffered. At your instance, you were the whistleblower, you got somebody arrested. FIR lost because of some payment being siphoned in his account. Later during investigation, it was found that you were the one who signed it. And you perhaps were instrumental in framing that person. Another psychiatrist. Framing that person. So this was the background fact. The employer chose conveniently to end your contract. He did not renew it. Now, how do you see it as stigmatic? These background facts will not be posted on the notice board. Nothing. So where is the stigma?
That is the second limbo argument. That was the foundation.
We don't find any reason to even wait for a minute. Let's not cut you short. You make your argument. We have given you our view, but we are amenable to change if you can tell us. Bully.
Now, firstly, as Lordship has already.
No, we have told you our view. Now you tell us, you dislodge us from our minds that this is an incorrect view, incorrect legal interpretation, incorrect precedent-wise. You tell us, we'll accept it. You tell us that we have taken a peculiar view of the matter. You tell us we'll revise ourselves.
The precedent is not available, but then the reading once again of 8A, what I again find, that the procedure that has been mentioned therein to be followed for the purpose of continuation.
Procedure are you talking about?
This review,
procedure is
procedure of review.
So self-assessment.
So whether this review has been done in my case.
Why not?
But the record doesn't reveal which was produced before the court.
Is there a requirement of giving you a reasoned order in review that for this reason we are not continuing your contract?
There'll be first of all,
we quite understand you have
self-assessment report.
Right,
there'll be a self-assessment report and there's a reviewing committee.
How old are you?
He served 20 years nearly.
Oh, yeah. And otherwise you'll be dismissed. You have faced criminal prosecution for siphoning of funds of the department.
I have replied to that, my lord, and I have said my signature are forced. That's a very, I have said it's a forced.
So therefore, who will decide? The High Court.
I'm not.
Is there a criminal case pending against you?
That is pending.
So would you not be an embarrassment till the time you get an acquittal?
No, but otherwise also, what I'm saying, secondly,
would it be fair for us to ask the employer to employ you and give you another lease of life by extending your contract.
Well,
They have
that-
chosen not to do
well,
it.
this was the foundation of issuing the order of release order.
The whole thing is there.
Plus,
That you are arguing now is nothing, no whisper in this.
No, foundational facts. What is the motive? What is the foundation? These
Yes.
arguments, what you find in many judgments, is not applicable here. It's a simple case of non-renewal of contract. And very valid reasons.
My lord,
They have
this-
been-
my lord-
they have not gone, they have not gone and been vitriolic against you.
my lordship will kindly see the order, one of the order during the course of the hearing that was disclosed by the
कुछ merit मिले, कुछ हमको pass करने. We are not finding it very interesting to spend more time on it. But we are not finding it interesting enough to give more time.
just only one order at page 108.
Yes, fine. Funds are right. Yes.
So, page 109. Third paragraph. So and so, on the other hand, submits that if the factual truth of the records are revealed through an
So we
affidavit.
are on page 109.
109.
They are order in the proceeding.
This is my lord,
One second. I will check it. Yes.
after filing of the affidavit in opposition, my lord, hearing was taken place. And then, my lord, this submission was made, my lord. If the factual truth of the record are revealed through an affidavit, the same would not be interest of the petitioner. Therefore, he submits that as the contractual period has come to an end, the petitioner was released from his contractual employment.
So why did you want it?
My lord,
Why did you want it? They would say that for this reason, we are not renewing his contract.
It's a good against them.
Why did you want it? Then it becomes a stigmatic and you have made it a stigmatic for you.
my lord, what I
And this
said,
is, we will
foundation,
just a
foundation.
minute, we will ignore this judgment because this is not in accordance with law.
These are the proceeding the order was put in the it's not. It's simple.
Well, their projected case is simple that
I mean, I would never ask for this kind of a reasoning, this kind of an affidavit, which exposes me. I'll not ask for an affidavit. You asked for it. And then in the same breath, you're saying that it becomes a stigmatic. This is the background. This is the.
I'm stigmating, I'm saying the foundation, my lord, I found foundation of passing of the.
If there is no word, suppose many a transfers, Mr. Saikia, you would agree that many government officers are transferred because the ministers would not want them. But they say that under the administrative reasons, he's been transferred. Do we look into it?
That is.
We don't look into it.
That is.
Therefore, if they would have even whispered that because of the person having been implicated in a criminal case, leading to siphoning of funds of the department, it is not proper for extending his service. I mean, they would have said that we would have been under an obligation to interfere without charge, without criminal conviction. That should not have been there. They have been careful. Heard discussed. And why Purushottam Dhingra? That's okay.
I have given seventh edition of this foundation of motive.
Till next.
Obliged.
33 and 34.
Have you heard this matter?
Yes, there's an order, last order, this is the last order.
Just a minute, give us a minute. whom are we referring to as inductees in the order?
Inductees are the person whom my learned friend represents.
Who are they? I mean, from the services.
There's two from services,
They are-
various departments.
Inductees.
Lateral entry, Miller.
Yes.
Line. All right, all right. I was not getting hang of this word inductee. Why has it been used? Though I have used that expression in my own order, but I was not remembering. Yes, we had asked for civil list and seniority.
Yes, civil list is, I think, there, Miller. But before that, would your lordship kindly have 2023-6 ZLT 805?
Parma.
No, Miller.
Then
Our High Court judgment on the same point, division bench.
let's see. Who's that?
Please come to para 20, 21, and 22, Miller. After referring to that OM of 4314 and all, as we have already noted,
Sir,
I'm sorry, para 20, Miller.
which page are you referring to this?
805, Miller.
No, 805 is a different matter on condonation of delay.
Miller, name of the party is Union of India versus Chanchal Nath.
Yes, it is the same page.
Yes.
Which page? There are no.
Well, paragraphs may vary. And
There is no
10 paragraph judgment. It's a 10 paragraph judgment. Where do we get 20 paragraph number 20?
Huh? Oh, my lord, I think the sentence starting with, as we have already noted. Was the
Just a minute. Throw this book. Either citation is wrong, case number is all right. But if it has been taken out from AI, then perhaps there is a complete wrong citation. If this is
not AI, my lord, it's a high court thing.
but this happens.
If you go delay condonation or delay.
Condonation of delay, 10 pages, 10 paragraphs. Then he spoke Sunil.
Or we'll give our copy. I can give some.
I will hear you on some other date.
Yeah.
When is it convenient?
Well, after vacation, my lord.
After vacation, long back, my lord, we are in truck. Let it be in the month
No,
of June.
because Lordship is not giving dates in June, that's why I thought, otherwise I have no problem.
June, let it be in the month of June.
Because Lordship is not giving date in
We are
June.
not- It's
That's why I said.
possibly could be in July.
Yes.
The only difficulty is that status quo order as on dates will be maintained.
Yes.
So we don't know what is the status, whether
Milord,
Yes.
this judgment which I'm referring is precisely on the point, same point.
I will show it, my lord, that there is a judgment, Hariharan, maybe.
No, Hariharan, Milord, Hariharan is a reference.
No, Hariharan has sent it because it's been overlooked by Mega Chandra. Yes. Yes.
Later part of June, Milord.
Yes. Keep it on.
Why this date? Tables are not telling.
The 23rd.
Who will this one?
Let both the appeals be listed. 23rd June. On 23rd of. Give that judgment in advance.
Yes, yes.
Yes.
Milord, just now you are giving, Milord. I think it is half now. 2023 4 GLR assignment. I think, Milord,
Mention of the judgment and give it to. I have the judgment also. That judgment of our division.
Yes, the compilation. No, do it, compile it properly.
Oh,
and give it.
compile.
we'll do that.
We'll do it.
Item 35,
I have given a note also, my lord. A note, I have given a note for the convenience of people.
Yes, Mr. Chamba, what instruction do you have with respect to permission to undertake two courses simultaneously prior to the notification of 2020?
At that, prior to the notification 2000, there was no regulation. But the affidavit of the UGC says, my lord, it says that if there is no regulation at that time, then the regulations that is in place issued by the university concerned will be applicable.
Okay. So where is that?
Then, my lord, my friend has filed an affidavit in reply that the university concerned also did not have at that time any regulation.
Any regulation.
Therefore, my lord,
Who appears for respondent number one? Yeah, is she employed somewhere?
No, the response number 7 in the writ petition and the response number 3, you have included later on, madam. He was appointed in GC College Skillshare Math.
At the initial stage, he was not made the party respondent, there is there at the post inspection. Lordship was initially, Lordship asked asked us that whether he's that particular person is interested or not.
That is.
They appeared, senior counsel, senior counsel, Sister Dr.
Appeared in CJ model.
She is not.
Last respondent number.
Here it is three.
Respondent number 3.
Here it is.
Respondent number 3 was.
No, respondent number 7 in the repetition. 3 in the writ appeal. 3 in the writ appeal. We writ appeal. Yeah.
3. You are the repetition.
Yes, sir. I am the repetition. The direction was given in the. I got the PhD. 16 marks was not, 13 marks was not. Then 9, then 19.
That's not interested. But consider. इसको क्या करेंगे? Consider the case. enough is enough. We have hard.
Otherwise, no, see, this is, I have no objection regarding consider, just the indicate law, see. Otherwise,
UGC has clarified the position. This was the
UGC has clarified position and against that we have filed affidavit law. UGC says that law, see, just the indicate law, see. Provided that two academic programs pursued simultaneously before issuance of these guidelines in accordance with the UGC's first degree and master degree regulations, status.
Have you filled up that post or not?
No.
You have filled up the post, consider. Consider.
Then lawsuit may,
The difficulty.
no, otherwise lawsuit,
You don't want the university to run, no? You don't want the place to be filled. There is no contender. You consider.
lawsuit may indicate that it is the exception from, otherwise lawsuit that 2 degree program, we will face difficulties lawsuit.
This is now
Simultaneously lawsuit.
accepted everywhere. 2 degrees, science, arts together.
That part.
You cannot be. Maybe.
Then lawsuit may remand back, then lawsuit may remand back the matter of the ZB lawsuit, they will take a first division and send it lawsuit.
For which matter I made the first submission that it is for the.
আপনার লাগে না লাগে support.
Was that the only ground for not considering? But take up.
Here lawsuit rejection was done by the governing body, so
Which I will consider. I mean, we are only affirming.
I will send it to the lawsuit.
This process was started when?
As per the rules, now we'll proceed. That's all. That is what is.
Lawsuit, we have no,
We need to specify.
lawsuit, we have no difficulty. We have no difficulty. We have no difficulty.
We have heard Mr. K. Gugoi for the appellant / state of Assam and appellants / state of Assam and others. And Mr. M. Sharma No, no, and Mr. M.K. Mishra for respond number one. The UGC / respond number two is represented by Mr. A. Chamwat. By the impugned judgment, the respondents have been directed to reevaluate the marks. Who are these respondents? Especially 3, 4, and 5. By the impugned judgment, the Director of Higher Education and the governing body of Debru College as also the selection committee of the Debru College have been directed to reevaluate the marks of respond number one. And if she is entitled to the benefit of 13 marks in terms of the guidelines concerned, she be given such marks, and thereafter a decision be taken at the earliest. The state of Assam has questioned the aforenoted direction on the ground that against an advertisement for filling up the post of assistant professor in the Commerce Department, the respondent number one had scored lesser marks than respondent number three, and that the respondent number one had pursued 2 degrees, one in commerce and the other doing a PhD in another discipline simultaneously, which debarred her for being granted additional 13 marks as claimed by her. During the course of hearing, we asked Mr. Chamua, learned counsel representing the UGC, with respect to the rule regarding the permissibility of a person undertaking 2 courses simultaneously. Mr. Chamua has informed this court that by virtue of a circular of UGC in the year 2022, a candidate could pursue 2 simultaneous courses subject to the condition that for one of the courses, distance education is permissible. The appellants are not willing to give 13 marks to 13 more marks to respondent number one and conclude the process of appointment on the ground that such circular of permissibility of undertaking 2 courses by the UGC came only in 2022, whereas the respondent number one had undertaken 2 simultaneous courses prior to such circular. The UGC circular makes it very clear that in the absence of any directions in that regard by the UGC, the direction of the university shall prevail. In the present case, there is no direction of the university with respect to the permissibility of 2 courses, 2 simultaneous courses to be pursued by any applicant. Now with the present set of rules and respond number 3, now with the present set of rules, comma, respond number 3, having taken up another assignment, being totally non-interested, being totally not interested in the assignment, comma, we find no reason to interfere with the order passed by the learned single judge, asking the response number 3, 4, and 5, and then asking response number so and so. 2, 3, 4. 2, 3, 4 in this appeal.
It's not in this appeal. No, no, in the. In the writ-
Here in this appeal,
Yeah.
asking response number 3, 4, and 5 of the writ petition, namely so and so, to reconsider the case of the response number 1 and conclude the process as early as possible because the post still remains vacant. With the aforementioned with the aforementioned observation, the appeal stands dismissed.
All of that. Yes,